Good evening, YouTubers. I hope you're having a wonderful day. It's Tuesday, 8 p.m. Eastern, our regularly scheduled live stream. I hope everybody's doing great. We should have a wonderful show today. By the way, as you come in, let me know if the audio and the video is working. When we started this out maybe a year ago, there was a lot of problems, so I'm always concerned that something will happen, and over the last couple of months, we've had a few hiccups as well, where everything was cut off and people were disconnected from the stream for some obscure reason. So just let me know how everything is. Let me just bring up the chat here. Excellent. Nope. Hearing myself. Great. So, as always, this is a live stream. Some people on the chat thought this might be a premiere. No, I have never done a premiere. From what I've seen so far, I'm not intending on doing a premiere. Makes no sense to me about recording a video and then somehow scheduling it for release and just participating in the chat. The concept doesn't make too much sense to me, and I've seen a lot of people complain that it's not really working very well and it's not very beneficial, at least in the current, the way it currently works. So no, this is a live stream, but as in all live stream, it's purely based on us communicating. This is not an opportunity for me to speak to you live. This is an opportunity for us to talk, because if it was about me speaking, I would just do a recorded video. It would be, everything sounded good. Okay, excellent. So it will be a recorded video and I just publish it, and that'd be easier on me in many ways. So this is about conversation. So it's all about you asking question and me trying to respond to it. You telling me I'm wrong. You telling me you have a different opinion. All is good in that realm. But if you want me to actually, sorry, to respond to you, make sure to put an @YouTuber Law before your comment, because there's a lot of commentary you'll see in the stream, and I cannot possibly read every single comment. So I'm only reading a comment that has the @YouTuber Law in front of it on my end, not on yours. That places an orange box around it, so I know to jump between orange boxes. Obviously, if you do a super chat, I'll jump to you, but you don't have to. As long as you put an @YouTuber Law, I will read out your comment and do my best to respond. If you don't know exactly, just put an I think probably and then the letter Y. It should populate right away. The @YouTuber Law, you may have to click on it, so it should work fairly well. We're gonna start in a couple of minutes. Let me just bring up, as always, the poll that I posted yesterday, just to see where we stand. And I thought originally this is gonna be a real squeaker, but it's not even close. You know, the first option that obviously was chosen was the FCC final response to the net neutrality lawsuit. The second one, which is about DeFi Media going bankrupt, so many of you have asked me about it, so I thought that was a slam dunk. But as always, I'm wrong about what you guys want to talk about, so by all means, it's going to be about the FCC. Let me just read out, before we start, let me just read out a few of the comments, see where everybody is. Big Yehuda, how you doing? Check Twitter when you can. There's a really awful thing Nintendo did. Court ordered people to pay $12 million to Nintendo. I hope you're well. I'm doing very nicely. I saw it on Twitter. I looked at it. Yes, that was the case we covered about 2 months ago, I would like to say, where Nintendo started shutting down different ROM sites, basically sites that are uploading their old games, enabling people to play old Nintendo games on whatever machine they want to, that currently exists, and most of them are going to be run on PCs. At that point, they filed lawsuit against, I believe, Retro ROM and Love ROM, and the immediate response was basically for those sites to be shut down and the entering of a settlement talk. And what Big Yehuda is talking about is that there is some information. I saw some of that documentation. I can't actually verify it, but it was on the Twitter that you sent, that behind the doors kind of settlement is for $12 million for these couples who are running the site to pay $12 million, with insinuation that they obviously will never have that kind of money. This is more of a large number to scare off other sites from people from trying to do so. Nintendo is going really heavy-handed against people that are infringing on their copyrights. That's not the first time. We've seen it many times, and we've seen more and more video game companies going after cheaters, after copyright infringers. Is that a good trend? I mean, definitely this lawsuit doesn't seem just. If you look at the settlement, my suspicion is that the true number is far, far smaller, something less, but I can't verify it since I saw it just through articles. I didn't actually pull down that case myself. So was always an interesting case. The fact that they're now settled, we knew it's headed toward a settlement, but it's, again, I think you're right. I think it's there to serve as a lesson for the world, and Nintendo somehow is serious, and they're gonna go after anybody that is actually making money off of their old games. Oh, Siri is talking for some reason. Brian Gibson, audio video looks good so far. Thank you so much. Bazi, please cover the Sargon pedophilia allegations against Andy Worski. Okay. I mean, I saw that comment also earlier on, so I looked into it because I myself didn't know about it. I don't like to jump into a middle of a conversation where I don't know any of the context and why people are arguing and what is the basis for it. But I did see a tweet by an account called Not Sargon that, at least on a couple of occasions, making allegations of pedophilia associated with this other individual. All I'm going to say on this matter, and it's not tied to anything specifically by these two parties because I don't know anything about their beef and what they're talking about, is that most situations, when you calling people names, it's going to be considered to be an opinion and then not the basis for a defamation lawsuit against anybody here. So calling people a crook, scum, a thief, even a killer, a murderer, most time the courts are going to look and say, you know what? Those words could include so many different proposed acts that effectively they're just opinions. They're not really insinuations of specific facts. And defamations can only deal in false insinuations of facts, false statements of facts that then cause somebody harm. So in most times, when you call people names that are associated with crimes, those are just opinions. I told you this before on two different cases. Obviously, we spoke about the Elon Musk situation when he called a British diver in Indonesia by that name. And we spoke about it probably close to a year now when there was allegations that somebody within the small micro community on YouTube is maybe a pedophile. At least there was just somebody just calling that out on a bunch of streams. And I described the fact that some courts have considered that word to be different, special, so loaded, and in fact insinuating a very specific and singular act. And at least one court said that that could be the basis for defamation, calling somebody a pedophile, because there is only one act that is insinuated through that name. There's not multiple acts like calling somebody a scumbag, somebody a thief or a killer, which could mean a lot of different things, true or not. But at least one court held that when you're calling somebody a pedophile, you actually making a statement of a fact, a very, very specific fact, not multiple potential facts. And as a result, was the basis for defamation. So it does play, at least in some people's mind, it's in a different category. It's very loaded and causes a lot of harm when you make that kind of insinuation. And at least in the past has been the basis for defamation lawsuit. So that's pretty much all I'm going to say about it, because the facts beyond that, I don't know. If you're going to choose to call people name, avoid that one. From a legal perspective, that's definitely one that you'd want to avoid. Jonathan Giglio, consider that social media companies offer verified account by denying people access to their digital identity. Is it possible they are committing fraud, get around Section 230? No, there have been cases where that has been brought up, but courts don't consider the whole verified functionality to be of any real significance. It's also just a feature provided and a feature that can be taken away, and as such does not provide any additional benefits. And if you read the terms of service, they actually define what a what the blue checkmark or the verified accounts actually are, it doesn't stand for much at all. So under the terms of service, they get around those frauds, and those terms of service have been supported by the courts time and time again. So none of that's going to get around Section 230. Conclansith, hello, how you doing? Sound and video are good so far. Excellent, thank you. By here, MJH, have a couple of questions about Star Control case. Excellent. I'm gonna take a look at it afterwards. Let's start today's topic, and absolutely I'll get onto it. You guys can ask anything you want. It doesn't have to be about the net neutrality, but let's at least start it. I'm gonna do maybe a 10-minute kind of monologue just describing the issue at hand and the case and what's been happening. And afterwards, I'll open it up. So just populate all your questions, put an @YouTuber Law in front of everything. So that when I come back to it in about 10 minutes from now, I'll read out and try to respond to everything. Let's start. Excellent. Net neutrality. So before we're going to start talking about the net neutrality case and what has happened over the past couple of weeks, let me just give you kind of like my own personal opinion on it. And the only reason I'm doing it, because generally I try not to discuss my own personal opinion on it, because this is not really an opinion-based channel. At least I try not to be any opinion-based channel, really more about the facts and the rationality behind the law. I think that it will give some context to potentially tell you that I'm not really biased on this issue. I'll tell you again. And so let me explain exactly what my position is. I am absolutely for net neutrality. I believe that the FCC is wrong in its decision. I believe the administration is wrong in its decision. That being said, I believe that this case against the FCC and against the administration, by extension, is wrong and is going to fail. The FCC, whether or not you agree that they made the right decision, is still within its right to make that decision. And that effectively is the very gist of this lawsuit. So what is net neutrality in its heart? Well, it's basically an argument over what seems to be very, very simplistic. Are internet service providers, are they effectively just dumb pipelines allowing for the transfer of information from one point to another without any manipulation or management? Or are they really information service providers? And the reason why that has been an argument has been largely because there's been historical changes in how the internet works. I don't know exactly what age everybody is on the live stream is, but I recall from the 1980s when I was a child playing what we didn't call the internet back then, just going online and messing around. The world was very, very different. And as it grew, our access point to the internet, in the beginning was dial-up, before there was broadband, was very much tied to content. Meaning I would enter the online world through CompuServe, for instance, and I would spend a great deal of time actually accessing information provided by CompuServe. After a while, we got into a bit of hacking into different forums and different networks created by different organizations. I remember always trying to get into, what was it? Radio Shack. They had one of the early networks. It was a lot of fun, and some basic games they had within it just provided internally to their employees, and us always trying to get into it. But our entry into the internet was both, but not only provided entry online, but also basically was our online world. And that only seemed to have grown in the succeeding years. And really the epitome of that kind of a world was America Online. And most people, when they got their little disc, or originally a little square little disc, then later on in a DVD format, when they used that to go online, they pretty much stayed within the American Online. There was always this option, one little square to go to the internet. But for many people, America Online really made its money by telling people, we are the internet. But very quickly, once that world started, we realized that the world is much bigger outside of America Online, and we stopped paying the high prices to America Online and just asked for basically access. And very quickly, we basically dumped this concept that however we enter the internet, somehow that defines what the world in the internet is, but rather we use that simply as a gateway into the greater internet, which is what we have today. So there was a time where access providers were also the information providers, but that has changed. Now, that has been an argument for a long time, even before we really had the internet, when the online world was still developing. So some of these FCC arguments were started back in the 1980s, but kind of mushroomed back in 96 when the Telecommunication Act was passed. And through a series of cases from 2005 to 2015, through a series of different FCCs controlled by both Republicans and Democrats, the FCC has tried continuously to basically control internet service providers. There have been basically a uniform agreement among all FCCs, regardless of the political background, that there needs to be protection against potential discrimination in the pipeline, because there is incentives among internet service providers to discriminate not only against other companies that might be stealing their business, especially in the beginning where companies provided both the pipeline to the internet and the information. So basically anybody providing information as a potential competitor. So there was an incentive to discriminate against those companies providing pure information but not access, but also against individuals. And there was a very famous case in, I can't recall the year. I'd like to say 2005, but it could have been a little later on. Maybe it was actually 2007. I'll have to check on that. But basically by Verizon. Verizon basically decided to not enable its own users who are accessing the internet to actually get to file sharing site. Basically, it determined that file sharing sites are potential hubs for copyright infringement. They wanted to block people. This is not about blocking competitors, but blocking their own consumers. Obviously, the FCC jumps in, says you are not permitted to do that. You cannot discriminate based on what is otherwise lawful activities, because just going into a file sharing site in itself is not illegal. This actually made its way up through the Supreme Court, and it was found out that no, as the FCC, you cannot actually control Verizon as an internet service provider. It was never a statement about whether or not what you're doing is right or wrong, but because right now the ISPs at that moment in time were considered to be information service providers and not really internet gateways and pipelines, that you could not actually impose certain regulations on them. So let's get into a little bit of what's going on here. Even though this is a lawsuit about net neutrality, effectively it's not going to be, and I'll explain to you why it's not going to be about the validity of net neutrality, of whether or not the FCC can regulate those internet service providers. This is a lawsuit about the power of the FCC, the power that's provided through Congress to the FCC and its regulatory power, and whether or not it's permitted to make the kind of decisions it has made, not only today, but for the past at least 13 years. Now, I'm going to try to explain why this is true, why this is not a net neutrality lawsuit, and why the administration and the FCC are most likely to win. I'm going to explain that not only by talking about this specific case, but actually at the end explaining a case that just came down about a week ago, where effectively the FCC and the administration lost a case in the Supreme Court where it was on net neutrality matters. Effectively, they petitioned the Supreme Court for certiorari. The Supreme Court rejected them. Effectively, that's a loss, and we're going to get into that and why that made sense, and why in that loss it actually supports the FCC's current position. So sometimes a loss works in your favor. So let me first discuss a couple of things here. What is the FCC supposed to be doing here? So let's take a look here. And here we have in front of us 47 U.S. Code 151, which is the purpose of the FCC. And it says, for the purpose of regulating interstate and foreign commerce and communication by wire and radio, so as to make available so far as possible to all of the people of the United States without discrimination on the basis of race, color, religion, national origin, or sex, a rapid, efficient, nationwide, worldwide wire and radio communication service with adequate facilities as reasonable charges for the purpose of national defense, for the purpose of promoting safety of life and property through the use of wire and radio communication, and for the purpose of securing a more effective execution of this policy by centralizing authorities. Effectively, it's the very purpose of the FCC to make sure that everybody in the United States has access to wire and telephone communication. That's also going to include digital communications without any discrimination whatsoever. And to effect that, the FCC, and not just this FCC, I mean, over time, and it was true, as much true in the Obama era as it is in the Trump administration, they developed certain goals, right? How are they going to get to that point? And the current goals are this: developing and implementing regulatory program, doesn't say much. Processing application for licenses, basically giving people licenses for radio communications. Encouraging the development of innovative services. Conducting investigation, analyzing complaint, and public safety and homeland security. Basically, there's a whole sort of goals that they have to achieve in order to make sure that people have access to basically telecommunication services. And one of the main goals, what's built out of it when they are promoting innovation, is the idea of they want to improve competitiveness, right? Because it's, for many, many years, telecommunication has been the house of a lot of monopolies. And the idea of the FCC is to really build competition not only among the large and small players, but basically create incentives for more and more investment. Sometimes the larger one do not want to invest. Maybe there's an opportunity for some smaller players to invest. So there's been already a very rounded kind of policy, implemented very differently depending on what are the priorities of the administration, but nonetheless very round kind of policies of how we're going to get to a point where we are providing really a great responsive telecommunication system to all the citizens, and in the process improving national security. Now, that brings us to the lawsuit. And what's in front of us here is actually the lawsuit as filed a few months ago, earlier this year. And if you can see, it's called Mozilla Corporation versus the Federal Communication Commission. And why is it called Mozilla? Well, because there were tons and tons of different lawsuits, and they were all basically consolidated in the DC circuit. So every single lawsuit when it came to net neutrality were consolidated. There's a lot of documentation, a lot of parties. Let me just give you a little bit of showing of how many people. Where am I here? Here, of how many people are actually arguing this point, and take a look here, right? Starting with the top one was 18 million rising.org, and I don't know who they are, but you can see how many different, these are all the parties that are actually included as plaintiffs suing the FCC here. So there's lots and lots of different parties, including, as you can see, of various states: California, Connecticut, Hawaii, Illinois, Iowa, Maine, a lot of different ones. So this is a lawsuit that has consolidated complaints by a lot of different parties here. Now, to understand what these lawsuits are, we have to just read the claims. It's, now, if you read the entirety of the lawsuit and you read the entirety of the response, which is what we have today, what you get to understand is that this is a very political issue for both sides. They both are writing basically tomes. They write tomes, not tombs. Tomes. I mean, large amount of expressive content about why their decision is correct, whether or not there should be net neutrality or you should repeal net neutrality. Why? Because they know that they're not just speaking to the court, they're speaking to everybody else. So there's a lot of fluff in here that effectively is not really important to the issue at hand here. So if we go through here and we actually look at the, let me put it up. And here we have, this is just a table of content, but we're able to go through it a little faster here. These effectively are the arguments. The FCC primary rationale for reclassifying bias is the broadband industry, as an information service is unambiguously contrary to the law, which is really the heart of everything, and we're going to be talking about in a second. The FCC's conclusion that bias, again, broadband internet, inextricably intertwines telecommunication with information services is unreasonable. The key word is being unreasonable. The FCC erroneously disavowed other sources of authority, though keyword is erroneously, and the FCC order is arbitrary, capricious, and contrary. The argument here is that the FCC made the wrong decision here. We can talk about the law in many, many different ways, and I'm going to give you a very brief explanation of what they actually are talking about. But make no mistake here. This is a lawsuit that tries to ask the court to substitute its own decision about right and wrong, what is best for society, in favor, in a contradiction to what the FCC, a federal agency, has decided. And that's at the heart of why this lawsuit is not going anywhere. Let's take a look here. If we jump now to, let me just pull it up. 1 second, page 34. And we're talking here about Brand X. Brand X is actually a case from 2005 here. And you would find that Brand X is an important case that both sides are citing. And both of them claim that Brand X, the case, mean completely different things here. Let's take a look. The FCC had classified DSL. Now, DSL, for those of you who don't know, was basically our version of broadband before we had even cable access. Forget about any sort of fast internet access we have today. But basically, it was another form of basically wired communication, slightly faster than what we were getting off of the telephone, dial-up telephone access service. So that was our first version of broadband. The FCC had classified DSL as a telecommunication service in 1988, but 4 years later it declared that the cable modem service was an information service. What they're talking about here is, for those who don't remember, when it all started, again, back in 2005, the FCC bifurcated what two different forms of broadband or fast access actually meant legally, saying that DSL, which was built on technology provided by the phone company, was effectively a service provider. Not actually a provider of actually pipeline, but actually a provider of actual content. While at the same time looking at broadband provided by cable company, they were saying those are pure pipeline. They are not actually provider of service. Now, the reason why the FCC actually saw it that way, because to them it made sense, because in those early days, while the dial-ups were still really heavily providing that kind of service, actually content, the broadband more and more really amplified the fact that through us you're going to get fast access. And while they were always providing some basic information, everybody ignored it and just used them as a pathway, a gateway into the internet. So I can't blame the FCC for thinking that those two forms of fast access are somehow different. But then again, they realized very quickly within 4 years that they made a mistake, and they reversed themselves and said, you know, everything is basically information service. Neither one is going to be considered pure pipelines. A divided Supreme Court upheld the cable modems order, the National Cable and Telecom Association versus Brand X Internet Services, in 2005. The court recognized that cable modem service included a telecommunication component, but this function was bundled with various other services like ISP-provided email, user group, file transfer service, DNS, whatever. The court held that given the record at the time, the FCC reasonably decided that the transmission component of cable modem service is sufficiently integrated with the finished service to make it reasonable to describe the two as a single integrated offering of an information service. The court also made it clear that these classifications were not carved in stone, but that the FCC was compelled to consider varying interpretation and the wisdom of its policies. Now, think about it. This case is being mentioned by people opposed to the FCC. But on its face, it seems that this case actually reads against them because it's the court actually ruling in favor of the FCC when the FCC actually removed a category, at this point cable internet access providers, from this concept of Title II, or rather a pipeline into the internet that can actually be regulated. Now, the reason why the plaintiffs in this case are actually mentioning Brand X is saying, you know what? The court looked at how the FCC made their decision. They first considered it to be there to be a difference between how cable internet access is provided versus how DSL, and later reversed. But the court recognized that the way they made the decision was reasonable because it weighed basically the fact that there's real basis for considering whether or not an internet service provider is providing purely access to the internet versus providing access and information. Is it providing one thing, just access, or is it really integrated access and information on top of it? The court considered the FCC's decision reasonable. Now, so this entire thing, if you remember back to my reading of the list, is basically to say that the FCC back in 2005 made a reasonable decision as to actually removing and no longer considering broadband company to be subject to Title II, subject to regulation, because they are no longer really pure pipelines, but rather service providers. But now it's different. So the entire lawsuit by all these entities is basically saying that the current process, what the FCC did to actually get to a point where they repealed net neutrality, was completely unreasonable. It was capricious. They not only have they basically not understood how the internet worked, because they didn't understand that back in the, I want to say olden days, but back, let's say in 2005, 2007, the internet looked very different. And back then we had service providers, ISP, that also provided us basically with what the internet was, like America Online. While today we don't really have that. Today it's pure internet access without really providing us with content. So what they're saying is the FCC understood the world as it was back in 2007, but they failed to understand the world as it today. As a result, their decision was completely unreasonable. They're trying to speak to how the Supreme Court looked at the decision made by the FCC back in 2007, saying there was reason then, there is no reason today. And then they obviously looked at some of the stuff you guys know about, which is the entire process by which the FCC actually makes decision, which is providing notice to everybody and then taking in different opinions. And there was a flaw, obviously lots of flaws in the entire system where they took in. And so they're using that to say not only doesn't the FCC actually understand the internet, but there was an entire flawed system by which people provided their opinion, so they weren't able to take in all of that knowledge and actually incorporate it into their opinion. The entire lawsuit is the FCC made a decision that they couldn't make because they were unknowledgeable, without any reason. It was completely capricious for purely political purposes. And that's why they're asking the Supreme Court to reverse the decision of the FCC, saying it's really not because of net neutrality, but it's because the process by which the FCC did it was simply unreasonable. So now we go into the decision as it was made by and now we're going to go into the response as provided by the FCC. And this is what's in front of us. Again, Mozilla versus the FCC here. And very quickly here, we're going to jump right into here. And it says, Brand X Court rejected arguments that cable modem service must be classified as Title II telecommunication service because the service contained some element of data transmission. Applying this test, the court concluded that the transmission component of cable modem service is sufficiently integrated with the finished service to make it reasonable to describe the two as single integrated information service offering. What's going on here? The FCC basically says that even then, the court supported the FCC decision that an internet, the broadband industry is not really a pipeline into the internet, but really are integrated with a lot of information services. But what's highlighted with all of this, because again, if you read the entire response, it's just lots of information justifying what they did. But effectively, the FCC's position is, we made a reasonable decision. You can argue that it's wrong. You can be against it. You can wish that we did something else. But we made a reasoned decision. We basically took information based on what we know and some of the goals we've set, including making the industry more competitive, and our opinion that the current regulation actually were hampering some of the goals that we as an FCC actually wanted, and some of the things that actually was required of us, because the regulation were actually basically holding back investments. Now, you can agree or disagree with it. I'm telling you, I disagree with that entire position. It doesn't actually negate the fact that the FCC made a reasoned decision. You can agree that it wasn't reasoned enough. You can argue that it wasn't the way it should have come down. But you've got a lawsuit here, effectively, that asking the Supreme Court to substitute its decision for a federal agency. And if you have followed much of what we've talked about in the past couple of years about the Supreme Court, it never likes to substitute its position for something that would have been decided by Congress or the administration, right? So if there's a chance for Congress to make a decision, it wants Congress to do that. It's not going to substitute. It's going to often interpret an existing laws provided by Congress, even when it's in complete disagreement with it, and the result does not make too much sense, because it's the role of Congress to pass laws, not of the Supreme Court. And the same thing here. Congress passed a law that created the FCC, gave the FCC certain powers to actually regulate wire and digital telecommunication services, but specifically exempted service providers. And if you watch all of the cases, basically, especially from 2005 to 2015, the court has been consistent. People think the courts have been inconsistent. There's some problem with it, but they're wrong. It's been extremely consistent, always saying that as long that the FCC can make decisions about whether or not something falls under Title I or Title II. Is something going to be considered a service provider, an information provider, or is it going to be considered pure pipelines into their internet? Now, depending on what the FCC has decided, the courts have stepped in to say, you know what, you can or cannot regulate those companies. So if internet service providers are, ISPs are actually providers of information, then the FCC cannot step in and actually regulate them and tell them, you know, you're not allowed to discriminate, because those fall under Title I, and those may not be managed and regulated by the FCC, at least not to a great extent. But if the FCC chooses then to take those companies and make a reasoned decision that they are now going to be considered pipelines into the internet, effectively Title II, then the FCC can in fact regulate it. So as long as the FCC made a decision which is reasoned as to whether or not something falls under Title I or Title II, the Supreme Court never jumps back in and says, well, the decision is wrong. It just says, no, as something that falls under Title I, you can do this. Under Title II, you can do this. And this is effectively what we have here. The likelihood of the Supreme Court jumping in and saying that somehow the decision was unreasoned is highly unlikely. There are definitely some legal experts who believe that there is a case here, that the proponents that are asking for net neutrality to be reinstated have something here. I disagree. I think that you can be in opposition to net neutrality and you can vote based on that. Vote for representative, vote for senators who support it, change the law, vote for an administration that support net neutrality, change what they tell the FCC. But this case is not going to succeed if you're expecting the court to jump in and tell an FCC that is empowered through Congress that it cannot make a reasoned decision because somehow it did not listen to enough people before it made its decision. Now, what happened, I just want to end this by saying, on one thing that supports my position on net neutrality is what just happened this past week, about a week ago, actually. The administration and the FCC petitioned the Supreme Court for certiorari to reverse the decision made in 2015. In 2015, the Supreme Court looked at the changes made by the Obama administration's own FCC when it changed the classification of ISPs from information providers to pipelines into their internet, basically saying that they are now Title II and can be directly regulated by the FCC, that can then tell them that you cannot discriminate against the people's access for as long as what they're doing is legal. The Trump administration and the FCC petitioned the Supreme Court to reverse the decision of the circuit court that actually supported that decision, that said, you know what, that decision was reasoned. As a result, as long as those ISPs are not considered to be classified as Title II, you can now regulate it. The administration and the FCC asked the Supreme Court to revisit, effectively erase that one decision. The Supreme Court rejected certiorari with indication that 3 out of the 7 justices actually would have voted to reverse that decision. Nonetheless, the Supreme Court actually did reject it. And why? Well, because there's really no issue for the Supreme Court to handle. It would have been a complete waste of time here. The administration wanted it because it wanted it to be a signal that will make it that much difficult. If you can actually erase a decision that actually supported those ISP being considered Title II companies, then it will make it that much more difficult for the other case, the case we're talking about, to actually succeed. Because even if the current decision is unreasoned, what are you going to fall back on? There's nothing to fall back on because the prior decision was negated by the court. But effectively, it doesn't really matter, which is why the court would rejected it. Because the reason why the Supreme Court, the federal courts, have really been either opposed to the FCC or supporting the FCC over the last 25 years has never been about whether or not a specific category is considered Title I or Title II. It's only based on, once they made that decision, are you then permitted to regulate them or not? And this is why this entire case is not going to go anywhere. Basically, the only way for people to fight net neutrality is not going to be through the court. It's going to be through the ballot box. You got to vote for it. And if there's not enough people to vote for representatives and senators or for a new administration in support of net neutrality, then this is what the Americans want, and the court will not jump in and reverse that decision. Anyway, those are my thoughts on the matter. Let me know what you're thinking. Let me go back and let's go through and actually make and respond to all your comments. Before I stop, let me make sure that everything is good here. Nobody's... Yep. Okay. By here, MJH, do you think Starduck's claim that they have the trademark to only Star Control but alien names and other names within the games have any merit? That's difficult because, frankly, they changed their story. that if you read the original complaint, there was an acknowledgement by Starduck that they only own the trademark to Star Control, and I would argue that that's correct. Now, I mean, that's the only thing that was passed on to Atari, trademark to the word Star Control. But the problem then becomes whether or not they have rights to Star Control once Atari potentially have lost it, and that's a big issue here. Did Atari lose that trademark because there was an agreement that made that trademark and all intellectual property revert back to the original developers in the event that they didn't, that the whole deal did not produce, I don't remember exactly how much, I think like $1,000 a year. So at that point, obviously that's pretty minimal amount. So if nothing was being paid, it was actually terminated. And there's an argument whether or not that terminated their deal. And so effectively when Starduck bought the trademark, Atari never had that trademark. So they effectively through bankruptcy bought whatever Atari had, but Atari never had it. So that's a question of, that's an argument to have, because I can look at the contract and I can say, yes, there's definitely a provision that actually cancels that entire the entire right to the trademark. But then again, I don't know whether or not it's true that they failed to pay the developers a certain amount. That's just a question of fact that you have to leave up to the court. So now the issue is whether or not all the other names, who owns that? Well, I don't have to register a name to own it. You know, Starduck says, we own the rights to Star Control. Our evidence is the registration. No, well, registration is not evidence that you own anything. It's just registration, right? There's value to registration. I encourage everybody with any valued mark to register their mark. There's legal value to it. But that's not proof of ownership. It's just registration in the event that you have a valid ownership. So in the United States, usage in commerce creates a trademark. So let's say that Accolade, the original publisher of the game in Atari, only had rights to the name Star Control. That did not mean that they necessarily have a right to every single name within the storyline, within the universe of Star Control, of those names, especially when the IP that the contract discussed, rights granted to Accolade through the publication function, had to do with their marketing. So whether or not any specific name used within the game itself and then used in marketing, whether or not that belongs to the original publishers or to Accolade and eventually to Starduck, again, will depend on factual elements that I don't have, which is whether or not there was any sort of commercial usage of those names early on. Was there trademarks in the name? Did anybody use them? Were they used in some advertisements of the the games? Were they used, let's say, in the back of the boxes? You have to get into the real usage of those names, because it's possible that those names have no trademark value, meaning nobody owns it. So anybody arguably that uses them now to promote a specific product, essentially marketing a product, may now gain access to them. So somebody can try registering them based on either intent to use it in the future or actually on their past usage of it. But that's going to fall into facts about what happened, 20 years ago, and I unfortunately don't have any information on that. Hope that provided some clarity. Conclanceth, which court ruled pedophile is a defamation? I'd have to look it up. My recollection, and I don't have very good memory, that it was in Northwest United States, somewhere around, and I was thinking in my mind Minnesota, something like that. There were at least a case there. I don't know if there were how many more, but I can see a logic being made. At what point is a name more than an opinion, but rather an allegation of a fact? That's where it's going to come down to. But there's at least some history of courts looking at this from that perspective and considering whether or not by calling somebody a name, you are actually insinuating a specific fact, because defamation is about facts. Christian Capsalis, can you cover the crazy amounts if false advertising in mobile games, and can you sue these countless companies for false advertisement? Let's see what we're talking about. Can you cover the crazy amounts if false advertisement in mobile games? I'm not sure what we are talking about. Crazy amounts in mobile games. Are we talking about pricing, or is the loot boxes, or you know, the microtransactions? What is it that you are concerned about? Just give me more information. I'll take a look. Just put @YouTuber Law. Unicorn Sprinkles, hi from Miami Beach. How you doing? Hardcore Hardware. But in the making of their decision, complicated the issue because if I recall correctly, they washed their hands of governing and regulation, including making decisions like that. Making the FTC have the power of the internet regulation, let Congress choose consumer rights and protection. The issue is that Congress never gets anything done. I'm completely with you that Congress is completely ineffectual. Doesn't change it from the perspective of the courts that that's the role of Congress. So if it's a job of Congress to make laws and the job of the executive to enforce them, require them to make some interpretation, but effectively to enforce them, then if Congress enabled the FCC to make those decisions and to make determination, because they did, about whether or not something falls under Title I or Title II, why would the court then jump in and say, you know what, you made a mistake, this should fall under Title? They look into whether or not you make some reason, but the bar is so low about making reasoned decisions ultimately. It doesn't have to be correct. The justices don't have to agree with that decision. It might be completely idiotic, but there could be reasons behind it. You could genuinely believe that regulation of ISPs actually kill investment. People can show you evidence all day long that it doesn't, that none of those companies were really heavily invested beforehand, and that change from 2015 made zero difference because they were never investing, and since then they can also show that no further investments have happened. That's okay. Doesn't mean that the decision was unreasoned. Now you would say, well, then somebody should manage this process. If not the FCC, then it's Congress, and Congress doesn't do anything. You're right. Then it's our jobs to hopefully vote into place people that would do something. And my little unrequested opinion is that the reason why this happened is because we've had over the past 10 years more and more people that are calling for senators and representatives who will not compromise. And that's the problem here. That throughout history, the reason why we have laws in place is compromise. Two different sides that have different opinions that come together because they realize that something has to be done. But about 10 years ago, the whole concept of compromise became an evil thing. We should not compromise. We should stand on our beliefs. And as a result is, nothing has happened. Now, Congress has never been particularly effectual, right? I mean, effective in their job. I'm not claiming that they were so great in the past. But if you're not putting in people that are actually willing to compromise in order to get something done, you'll never get anything done. And that's what we have here. But it doesn't mean that now the executive should take on that role. If Congress wants something else, it needs to pass laws. It shouldn't then basically shirk its responsibility by hoping that everything is going to be taken care of by the administration or the courts. And they basically, all they do is hold hearings, call people, threaten them, but otherwise they really don't do anything effective. Clanthith, how does the names of the consolidated lawsuits work? First to file gets the name or the biggest claim? I don't think either one of them necessarily. I don't often have direct information on that because we see it in, I've seen it done more in private sector where it's more like class action lawsuit where the courts make decisions based on the capabilities of the law firm, because the biggest thing here is about which law firm can handle this. So in a large class action lawsuit, every law firm wants to be the lead law firm on it because they're going to get the lion's share of the money. They're going to get the big dollars, and everybody else, all the other law firms, are going to get a far, far smaller share out of this lawsuit. So everybody wants the lawsuits consolidated, but everybody also wants to be the lead law firm on the matter. I'm not sure how this is done here, whether or not it's the courts actually looking at the capabilities of the law firms to handle a case of this magnitude. This is obviously a massive lawsuit. Look at how many parties are involved here. Who can actually manage that entire process? Who has the manpower they can put behind it? I'm guessing that it's the same process as through a class action, but I don't really know. Unicorn Sprinkles, don't forget to click thumbs up, show some love. Thank you so much. Please do. Marin Peppelman. Hey YouTuber Law, how you doing? Just learned that Apple made a deal with Amazon to sell more products on Amazon. As part of the deal, they required any other sellers of refurbished Apple products on Amazon to be authorized Apple service providers. This means any small refurbished companies that aren't Apple certified are now getting kicked off, or at least are forbidden from selling Apple products on Amazon. Isn't this a case of tortious interference? There is... Okay, I have to read more of the details on that. Any other seller of refurbished Apple products on Amazon to be authorized Apple service providers. I don't see how any of that... Now, they can't enforce it, right? But if there is a deal that Amazon has to agree to kick off people that are not authorized, but if Amazon then becomes authorized, I mean, if Amazon, because Amazon sells some of those products directly and some through other retailers. If Amazon is not selling anything, it's only through third parties, but it's only going to accept authorized one, there is an argument to be made here that this is a monopoly behavior. This is anti-competitive on enormous level here, because obviously Apple sells its own refurbished products, and if it now goes on the largest market in the world and strikes a deal that kicks off everybody who somehow doesn't get certification, which I'm going to assume is probably paying Apple something in order to get certified to begin with, to be authorized here. That's an incredibly anti-monopolistic behavior, and I would think this would spark some antitrust examination of how the structure happened. I mean, we've seen stuff like that before that the government had jumped on top of, involving the sell of books, and whether or not Amazon or Apple strikes deals with publishers to sell their products, but will keep it at a certain price. I don't see this as being very different, because it's a way of getting around the concept of lowering price by calling them authorized. As a result, they're able to maintain certain pricing that then supports Apple's pricing, not only of their own refurbished, but then of their brand new product. So I hope what you're saying is wrong, but that's actually a very interesting case. I'd have to read more about it to see if I can get some details on it. Thank you. Again, everybody, I see there's just tons and tons of write-ups. If you want me to read it, if you want to tell me I'm wrong, and you want me to respond to, you have to put an @YouTuber Law in front of your comment, because otherwise I'm just skipping it. I'm going from @YouTuber Law to @YouTuber Law. So if you put a comment you want me to read, you forgot, just copy it and put it @YouTuber Law, and I'll absolutely read it. July Jeter. Thoughts on the CNN versus White House? Oh my God. I think everybody's reading too much into all of that. I think that people got heated, and the reporter probably did not completely act the way he would have chosen had he felt not pushed. And I think that the president, had he looked back on it, probably would have chosen to act differently too. But I think people are just making way too much of it, or whether or not, how he behaved toward the woman who was trying to get the mic. I don't think he did anything wrong. Didn't look to me like there was any sort of real force being used here. And I don't think the president is not permitted to speak this way to somebody that he perceives is attacking him either. I don't think that I don't think there's a requirement that we live by some rule that are established by, by history. Presidents have always acted this way. As a result, if you act differently, that's wrong. I just don't see that. I don't give that much credence to the past, to the concept that somehow if it was done this way in the past, it's somehow better than how it's done now. American people voted for this president. He is behaving the same way he behaved before. You can like him or not. That's your decision in the ballot box, but you have to respect the fact that the Americans have voted for him, and many like the way he acts, the way he behaves, the way he speaks. It's more plain speaking than many politicians. And the same way with the reporter. I don't think the reporter acted out of line. If we are not going to give too much credence to the past and how things should have been handled, what would have been handled 20 years ago. If it's good for the president, it's good for the reporter as well. So I just think that there is no drama here. I think that this is the new norm here. We just have to live with it. Steve Connor. Seems chat is dealing with the ball question, ATM. Chat is dealing with the ball question at the moment. The ball question. Am I missing something here? Give me some information, because I'm not sure what the ball is. Apple authorized service providers are companies that have, Marlon Peppelman, that have struck a deal with Apple to, among others, buy 2.5 million in products directly from Apple, and puts restriction on how they handle repair. See, that will be really problematic if there's a contract between a company that holds a monopoly on an entire ecosystem, right? Because within Apple, it's a complete and utter monopoly. You can't go anywhere else, and it's a relatively significant monopoly, even in consideration of everything else in the world. And it then signs a deal with the single largest online market in the world, requiring authorized service providers on their platform. I think there's a real antitrust question here. I think that's highly uncompetitive, and I think courts here, because U.S. courts, when they look at antitrust, they look at pricing mechanism. And from what you provided me, because I don't have any other information, that has a significant impact on price. If there is an agreement between a monopoly and the largest retailer to only allow for authorized resellers of a product, because it's not illegal for other people to resell or fix those products. It has zero legal implication here. Then they are then artificially keeping prices up higher than what the market would otherwise bear. This is something that triggers antitrust. The courts would be all over that kind of question. So if that's the case, if that's the kind of deal that there is, I think that there'll be an investigation that would go on for years and years. Juan Salazar. I'm starting law school next year. Any tips for law school, and how was law school for you? I'm probably not the best one to give advice on law school, because I went to law school without the intention of actually practicing law. My background was in international finance, and I was doing research in grad school, and I was getting into a lot of issues of discussing the law and understanding it, and I went to law school for that purpose. Eventually, I had to get a real job, and I became a lawyer, but that was not my intention. So my time in law school was very different than other people's. I did not really interview with the law firms. I was not involved in things that most people that are interested in law as a career were. I did a lot of research, a lot of work involving my own interest in toys and games, a lot of video games, and because that was my intention to be involved in back then. I mean, I ended up getting there through the legal practice, but my intention was really to work there from a business perspective, from a finance perspective, not from a legal perspective. So for me, if I can tell you that law school obviously is difficult. It's just stressful. I chose Stanford largely because it's not competitive, meaning once you're in, it's not a competitive environment. It doesn't engender that. There's other schools that are known for being extremely competitive. So I didn't want that kind of environment. So that in itself reduced a lot of the stress on me. But for me, it was finding something else to do, something outside of law school, because law school can consume your every day, all day long. There's no end to it. And finding something else. So for me, it was exercise. It was largely running. I started running, and I ended up running 10 miles a day every single day for 3 years. Then I connected with other people who were doing it, and that became something we did. So it was about finding some sort of a hobby that allows you to connect with people and basically get you outside of the stress of law school. At least that was what worked for me. Thragash, I hope I'm saying it correctly. What do you think of the claim in Starduck's suit that Paul and Fred are fraudsters who never owned any copyrights to begin with and thus defrauded Accolade and everyone else? I think it's false. I think that, and I'm only going, again, I have zero knowledge of any of these individuals. So I'll tell you why I think it's false. Because that's in complete contradiction to what Starduck said in the original complaint versus what they're saying in the third amended complaint. In the first complaint, and if you start reading the interviews and even in some of the communications to me that I received directly from the CEO, it's clear that there was a recognition that they owned copyrights in the game. There was never claim. Starduck has always claimed that they just want to produce their version of a game under the Starduck name. They're not claiming any rights to the copyrights or those original stories or the characters that might be trademarked or copyrighted. They were creating a whole new story and they're connecting it to their own trademark. And that's one argument. But and there were definitely hints in the original complaint that maybe Paul and Fred did not own everything they're claiming to. But by the time they got to the third amended complaint, the legal strategy changed a lot. And basically saying that they owned nothing, that they defrauded Accolade, that they didn't have any rights to it at all. So I think it's false because the third amended complaints are saying something in contradiction to what the first amended complaint. So that's why my perception of it, that it's false. So, and I don't think it'll mean anything. Because how in the world are you going to ask a court to go back to, when is it? Now I forgot the name. Was it 1984? And see whether or not the contract was improperly entered into. There was no meeting of the mind. Maybe it should not have any bearing at all because some of the party did not have rights. Are they going to go back and start interviewing every single person who worked on the original Star Control and what kind of a relationship? Did they have an employment relationship, some independent contractor relationship? Those allegations will have zero bearing on the decision here. It's going to come down to the 1988 agreement and what passed from Accolade, from Paul and Fred to Accolade and eventually to Atari and to Starduck, and whether or not the trademarks that were passed, are those still valid or were those canceled, and what about the other, and what that agreement says about copyright and who has a right to it. And then maybe they'll get into, well, if this is what Starduck came up with, is this actually an infringement on copyrights that are owned by Paul and Fred in the original Starduck 1 and Starduck 2? Or are they more of an offshoot of Starduck 3 that would have been passed along to Accolade through Atari? But it's going to focus on the 88 agreement. That's really is the most critical instrument. That's what defines everything, the relationship. That's what gives the right to passage I don't think they're going to go all the way back to the early 80s and try to figure out whether or not Paul and Fred really had any rights to those properties when they entered into the agreement with Accolade. I think that would be impossible to reconstruct, 30 years later. Commissar Keck. Thoughts on the ballot fraud in Florida and other states? That it's... Obviously, I'm in Florida. It's a shame on my state for not having fixed this nonsense. I mean, 18 years we couldn't fix this? Look, Florida is about as purple as you're going to get. You can see what's happening here. It's down to the wire. So yes, every single vote counts. Now, there's always has to be a rule about when you can vote and when the date stops and what potentially is, what votes should not be counted or be counted. But the idea that we can be here today because my state still relies on paper documents that are then scanned into ballot machines, that it still allows people to send it by mail, but doesn't have a post office that is capable of actually delivering that mail on time, that it can not create a system that actually has a definite cutoff of when mail is being sent, should votes be considered based on when it's sent or when it's received. Normally, when it comes to federal issues like taxes, it's when somebody sends it, not when somebody receives it. It's a shame on the state for being in this position here. It's embarrassing here, and knowing that it always falls this way, literally. And it's not just in federal. I mean, you have to understand, we do it locally here, where we have decisions sometimes that people can win based on literally sometimes handful of votes here. And it's shameful that we cannot fix it and that we are holding up the entire country based on our inability to run. Just, it's not about legitimacy. It's just we're somehow not capable of running a proper voting system, of investing enough in voting machines that can actually be reliable, secure, and where the rules can be input in there so that we don't have this kind of idiotic decision problems with post office not delivering votes that have been sent. So what do I think? I think that it's, yeah, I'm embarrassed by my own state, and I think everybody in Florida should be embarrassed. Jared Rogers, are you a secret dragon? I have no clue what that means. Sounds awesome, whatever the hell that means. So, if I have a choice, I would say yes, but it could be that it means something completely terrible, but I have no idea. July Jeter. CNN is saying revoking his press access infringes on the freedom of press. That's absurd. That as far as I understand it, the White House is not obligated to grant any specific individual access to the press pool. That's a privilege that's been bestowed for 200 years on specific organizations and specific individuals working for that organization. There are a lot of news organizations that don't get to come into that room, and there are a lot of people that want to have access to that room that don't get. You have to understand that everything that the administration does, by necessity, has limited access to it. How many people should be allowed on Air Force One? How many people should be allowed in the press pool? How many people should be permitted when the president goes on a specific trip and needs access to maybe small venues? So everything is controlled, and the idea that by not allowing somebody in there, that's somehow infringement of the press, I think that's absurdity. That I'm going to assume that CNN is not barred, that it's this individual that is barred. I'm going to assume that he's not the only individual, because there are a lot of reporters who would like access to that. And the idea that every time the president does not allow somebody in, that somehow infringement of the press is ridiculous. I think it's colloquially infringement on the freedom of the press, but it's not legally that way. Again, you don't have to like the president. You just have to recognize that Americans voted for him. You want something else, vote for something else. Oh my God, that's a lot of number. 687864846351. My God, keep up the good work. Thank you. Jared Roger. Oh, I guess the Secret Dragon. I don't know what that means. John Taylor, what made you decide to do this channel? So, I started the channel a little over 2 years, right? I would say that I thought about it for about 2 years. And in my thinking, I thought I would enjoy it. Really, that's it. I mean, I had thoughts about how I can contribute to the community because I'm an avid YouTuber. I watch content. I consume so much content. It's my primary way of consuming content, I would say, more than anything else. So there was all that, you know, where would I fit in, how I can contribute. But for about 2 years, I thought that I'm just going to enjoy this, but I didn't know how. And it's once I figured out how, basically I watched a video of another YouTuber saying, this is how I do it, literally, He gave a formula. I thought, I can do that. But that was it. I just thought this would be fun and nothing else. So I just didn't know how to start. I didn't know what to do, how to come up with a storyline, how to say something, how should it all be set up. So that's what was holding me back, when in fact, once I had the formula, I started, and literally I never stopped. I mean, in 2 years, I'm like, not just on YouTube, but all the videos that I've created and uploaded, I mean, in excess of 400 videos. And it's, from everything that I do professionally, it's by far the one thing I enjoy more than anything else. So I was correct. Marlon Peppelman, thanks for the insight. This channel has provided a big and interesting insight into the law. Please keep up the good work, and thank you for being you. Oh, thank you so much. That's really appreciated. Commissar Keck, thoughts on the voter fraud in Florida? Just did that. John Ferguson, could the FCC categorize the high-speed data network as regulated utilities, be considered a government taking? The network were built under a different legal status. No. And we know that because the courts have approved it already, right? Because the courts have already looked at both sides of it, of the FCC considering those pipelines to be under Title II versus Title I, and the courts have already looked at it on both sides and said that's reason. So they've already basically opined on the constitutionality of the law as passed by Congress and as implemented by the FCC. So it's not a taking, because the government is not actually taking over. It's regulation, and reasoned regulations that are enabled through Congress that otherwise are not in violation of the Constitution is not going to be stopped by the courts. And again, the courts have looked at it multiple times. So I don't think it's taking. 3 Shannon Rocks. You seem pretty well versed in video game legal issues going on. Do you know anything about the Crytek versus Cloud Imperium? If so, what do you think? Do I know? I'm sorry for chuckling. Check out the playlist. I probably did 13 to 15 different videos on it. In the past month, I probably did 3-4 of those videos giving you the status of what's going on. So there's just, yes, I'm very well versed in the Star Citizen, Cloud Imperium, the entire storyline there. But the current status is as of the last video, and I have an entire playlist on it. So please take a look. There is no storyline, no story at all that I do that generates as much passion as Star Citizen. That case, more than anything else. Originally, I thought, you know, the Sargon versus Aquila Hughes thing did for a while. Star Citizen dwarfs it by far. Most passionate people on both sides of the aisle. So, yes. Take a look at the playlist. Again, are you a secret dragon? Let me know what that means. Old Bill... Let me see. Hold on a second. I don't know. Must be a code name for something that I'm not understanding. Old Bill Overhill. In Colorado, you have to drop off or have it delivered before Election Day. Have it delivered. Okay, that's interesting. So if that's the rule, I can see why that would be a good rule, because that's a very definite deadline, right? I mean, if it's not received, it's not received, and everything else is invalid. But what happens when you send it out? And maybe it's just hypothetical, because I don't know the hundreds of votes that are not going to be probably counted that are stuck in the post office. What if I mailed it a week in advance? More than enough time, right? Mail delivered locally is, you know, within 2 days here. And yet it doesn't get delivered for over a week, 10 days, 2 weeks. So because of the inefficiency of the post office, my vote doesn't count. So you can see why some people consider it to be unjust, right? I did everything that it's needed, yet a federal agency failed to deliver my vote in time. As a result, my vote doesn't count. So it's a nice, clear rule, and it's probably what's true in Florida too. I just don't know. It just definitely doesn't make you feel any better. Where again, if I mailed it on the day of election, my fault. But right now, it seems like it's the fault of the post office. So who's to blame there? And should those votes be counted? No, that's the difficulty. Commissioner Keck, thought on RBG's recent health issues and who might replace her if she retires. I mean, I have no idea who RBG is. I mean, is that like RBG? I told you many times, guys, I don't follow the news. I only follow news of things that interest me. A lot of times it's, you know, video games and just the online world, some First Amendment issues that interest me. So I just don't know what RBG is. Let me know. John Taylor, any tips on how to know if you have a good lawyer? Oh my God. Tips on knowing if you have a good lawyer. That's hard to know, because it's so contextual based on the advice that they give you. And it kind of depends on it. But what you want to test them essentially is on their experience, because it's true. Lawyers get trained to be generalists, but when they start their job, they get to be very much specialist. And the value and how good a job an attorney does for you is directly proportional to his experience on a specific case. And sometimes it makes sense to hire somebody that has very little experience because of the nature of the job. But when you get into more and more complicated stuff, let's say you're involved in a criminal lawsuit and some very, very high-end civil lawsuit, you want people that have been there, done that, have won, but also have lost and have all that experience. And so that's the kind of questions you want to ask. You know, you want an attorney that you can ask a question and it's just coming out. You know, when he starts talking about this client and that client and that and how that turned out, you know, his response is based on experience. If he's responding to you based on this is what the law says, and none of that is, he doesn't have any sort of information about, you know, when I dealt with that client or that client, I'd be concerned that he doesn't have that experience, that he may know the law very well, but doesn't have the client experience to know how things are very different once you have very specific facts and how they turn out in court and how this particular judge would look at it and what different jurisdiction would look at. So when I ask, I think you should pay attention to how much information is provided based on the clients that he's worked on before. Night 1, thank you for that information you gave to me. The copyright flag was revoked and my friend channel reinstated within a half a day of the counterclaim being accepted. Thanks. Oh, thank you so much. I'm glad I was useful. Commissar Keck, how much do lawyers make on average for entry-level positions? Oh, well, I haven't been entry-level position in a while, but it's difficult for me because, again, to know it, you'd have to be involved in the hiring of people out of college, and I haven't done it in a while, and it's very, very dependent on what state and within the state and what city. To give you an example, when I was hiring attorneys out of college, let's say about 5-6 years ago, in Miami, you were looking at from 45 to 65, depending on some of the experience, some of the stuff they were learning. But larger law firms were able to pay another 20-30,000 within the same local market. Now you take that price line to New York, San Francisco, the starting point would have been much higher than that. Now you have to consider that on average, by far, most attorneys are working either sole practitioner or small law firm. So when you look at numbers that people out of school actually get, it often is inaccurate because it's based on on the salaries being paid by some of the largest law firm, and most people don't end up actually working very long in those law firms. So it seems higher than it actually is. And so most attorneys settle for not an extraordinarily high salary level. Thragash. One more questions on the Star Control suit. Any thoughts on GOG and Valve being brought into the suit, especially the bit about GOG's contract indemnification clause? I think that it's a legal strategy more than one that's going to get anywhere. Basically claiming that these companies aided in the copyright infringement because they were they were informed that the games being sold were actually owned or licensed or under control by the defendants and not by Starduck, and as a result it should have been taken down. I don't see that as going anywhere. I think this kind of either contributory infringement or assisting in the infringement or supporting it, something like that, is not going to go very far, because I don't think this lawsuit will go to final trial. I think that that's where the parties are pushing it, and this can last for 2 to 3 years. This needs to get settled. And I don't think the platforms are in any way liable for any for them putting up the games, because ultimately they don't have any real way of knowing what to allow, what not to. And what happened was, before this round of DMCAs, Paul and Fred issued DMCAs to those platforms to take down the Starduck beta and stuff, and they were taken down. And it was only and the concept that they should have acted beforehand. They should have known that before they received DMCAs or afterwards. I think that's incorrect. The only thing that the law exposes these platforms to is in how they respond directly to DMCAs, and not knowledge of infringement, but in response to DMCAs. And unless they have knowledge of repeat infringements, the only time when they'll be held liable, that if you see somebody repeatedly infringing, but this would not come to it, because it's not as if Starduck was, these platforms were hit with just tons of different DMCA relative to Starduck, so that you consider Starduck to be a repeat infringer. So what we're seeing here is a situation where the platforms are going to be immune from liability here. But this is really an attempt to make the case a little bigger. It's a legal strategy. I don't fault Paul and Fred for doing that in order to gain some advantage to make the case bigger than what it is. But I don't think it's going to go anywhere. I hope as I was speaking, I think sometime when you speak, at the same time you're thinking, the words get jumbled. So I hope I provided, that was a clear enough answer. If it wasn't, let me know and I'll try to state it again. Oh, Internet Law Review, $5. Thank you so much for the super chat. The one and only notorious RBG, but you can call her Justice Ginsburg. I apologize. What was the question before about what's going to happen? I think that she's near retirement age, and this is going to happen as long as she's healthy enough. I think that there will be political pressure on her to stay past the next 2 years, because that's every single time when, if the Democrats are in power, people urge the conservative justice to stay in place until the new administration and hope that there will be a change in the administration. I think that's the kind of pressure on her. I hope that she doesn't listen, not because of who might be put on her, but I think that sometimes people reach that point when they know that they need to retire for health purposes, to enjoy the remainder of life and stuff like that, to take care of themselves, because, you know, there's a certain amount of stress has come with being a Supreme Court justice, and I hope she does what is right for her, not whatever politics dictate. John Taylor, thank you so much for the super chat. Thanks for always having great engagement in your comments and now in the live stream. Thank you so much. I truly enjoy this. It's one of the highlights of my week to do that. Let's see if I... I have to find where I was before. Oh, 3 Shannon Rocks. I had no idea you covered so much on the Crytek thing. I just saw your videos. Thanks for great coverage. Thank you. It's a case I look at a lot because it's actually very, very interesting, so I enjoy it. Old Bill Overhill. Hey, we have to pay postage too. You can vote in person and check if received. I can't help. I mean, I know that we need mail-ins, especially with elderly, and I can accept that. It makes it obviously easier to do, and I know that there's a risk in telling people to vote online. Obviously, it can be much more easily hacked and all, but I can't help but saying that's where we're moving to. Because all these problems, if you remember back to the Gore Bush problem with the Chads and what kind of how we made a hole in the ballot. I mean, do you know how we vote in Florida? It's like the way middle school was. I have to fill in little bubbles on pieces of paper and then scan it in, you know. And if I don't bubble in correctly, if I don't fill up the entire bubble, the machine may not read it. It's not as if it's technology first where I'm clicking on a computer and maybe provide me with some sort of a receipt. Just the opposite. It's paper being scanned in. So I just don't know why we have not found a way to move beyond it, to develop the technology to make it both secure, simple, and easy. Makes no sense to me. Colin Winter. Regarding business negotiation with a YouTuber after having filed for an IPO and failing to reach purchase threats exchange. Month later, YouTuber deletes that video just a few weeks before the IPO, not for copy retweet. If I understand the question here, Colin Winter, is there anything else here? Okay, so a business negotiation with another YouTuber after having filed for an IPO and failing to reach a purchase threats exchange. A month later, YouTuber deletes that video just a few weeks before the IPO. Again, unless there is... Most times when you are negotiating agreements, you, especially if it's a large one, you would have some sort of an initial letter, basically a letter of an LOI, a letter of intent. But 95% of the time, it's not binding. I've done ones when it's binding, where we intend to do something, these are the terms, and if we can't reach a real agreement, we're still going to hold that the letter of intent is binding. it's very, very rare. Usually it's non-binding. Definitely if you're negotiating and you don't have anything to show for it. And the fact that through the negotiation and through the failure of the negotiation, you then suffer some damage, that's frankly the cost of doing business. Now, threats and everything else, and how should people treat each other in business, and you know, a lot of time when you act like a jerk and you cause people losses, it's a small world. People learn about it, and you're going to suffer later on. It happened many, many times. I've known people that started tech company, took money from people, you know, treated it as disposable money, lost it. They're not going to get financing from the next, because people know about it, and I see people that end up paying all the investment back in order to make sure that they have a chance. And I think that that's a certain bit of karma. So from the details you provide, there's probably not any legal ramification unless there's some sort of a binding letter of intent that bound the parties to a certain result, even though the negotiations broke down. Generally, there isn't. But doesn't mean that there are no consequences. It just usually doesn't come with the support of the law. Commissar Keck. Oh, that's what we just talked about. Super Iron Bob. RGB, Ruth Bader Ginsburg, to reiterate the prior question, what are your thoughts on the prior health? Spoke about it. Thank you so much. I didn't think about that at all. Wow. Roxalarge. No idea. Do we have an update on the Sargon versus Aquila case? Is it possible they have reached a settlement so we won't hear it again? Not as far as I know. I spoke about it on Twitter. Didn't really speak it here. I looked it up because it makes no sense, right? This is now, what, 5-6 months since the motion to dismiss. Normally, 3 months you're getting it. What's going on? It made no sense. Then I looked at the file, then I looked at the judge, and I Googled it. And what happened was that the judge, this is a district court level, got a promotion. Trump promoted him to be to the circuit court. So there is no judge. Nobody to make a decision. And that's what's happening here. So nothing happened. I just checked that maybe 2 days ago. They haven't yet assigned a new judge. So this should have been, the motion to dismiss should have been already ruled on. But the judge has a new job, and so he's not handling this. So how long before they actually appoint a new judge and somebody looks at it? It might be happening behind the scene, but the digital records don't show a new judge having been assigned yet. Golden Mongoose. Hey, Lior, I've been busy the last couple of streams, but it's good to see you are still looking sharp. Thank you so much. I appreciate it. Nice to see you back. Super Iron Bob. Do you believe that the law is accessible enough to the layperson? What could be done to improve the ability of lay people to understand the law? That's a great question. I don't think it's accessible at all. I think it's by purpose. Certain things are changing. You have to say there has been the trends in law, and that's started before there was an internet, is the commoditization of legal services. Basically, the legal profession, like every other profession, benefits from a monopoly on knowledge. And while there's always been, you know, very esoteric books on law, and there have been law libraries, there's not really been an ability there have not been tools to take law and actually explain it at a very fundamental, how do I use it, to a lay person. And that has changed as law become more commoditized, and suddenly, before there was an internet, you know, true in Florida, but true in many, many states, you know, the Bar Association got together with the Realtors Association. They got together, drafted a standard real estate contract. Well, before we had huge number of attorneys working on residential real estate, now it's pretty much a dead industry. And because people can literally use standard agreements to buy and sell their homes, they don't need anything special from an attorney. Then they can engage, let's say, a closing agent who is not an attorney to do it. So the commoditization of it is help people do things, even if they don't understand every little aspect of it. And I think that we've seen that more and more in law through services such as LegalZoom and Rocket Lawyer and stuff like that. Not saying that what they're providing is necessarily wonderful and great, but I can appreciate their commoditization of specific things that people can access without having to always engage an attorney and pay him for the monopoly on the knowledge that he has. And some of the stuff I'm working on, this is like a little cheap plug for me. I'm working on decommodization of legal knowledge and trying to deliver that. So you will see products over the next few weeks and months that I'm promote for myself, but that's essentially it. Take knowledge about specific area, deliver it in a very compact, very manageable process so that it's commoditized, no different than, you know, you buying a form online effectively. So that's the idea. But I think that we can do a lot more, and I think it's moving in that direction. Commissar Keck, what glaring issue do you think needs to be improved about our legal system? I think that we need to expand what it means to be in small claims court. I think that we need to expand on the dollars. I mean, depending on what state, some states are only things up to 5,000, sometimes under 10, that's 15. I think that the amount has to be large enough so that people can represent themselves in front of a judge, don't have to engage an attorney. And I think the amount has to be increased, probably around 25,000 in modern amount, not, you know, in Florida I think it's like 5,000. It's ridiculous. So a lot of things people have to engage attorneys and go to full-blown lawsuits. And so I think that that's one. I think that we have to have a better form of a small claims court, and I think we need specialized judges. We don't have that. We have, you know, some specialized commercial judges in Delaware. New York now has it for businesses, but I think we need very, very specialized, especially business-oriented judges who know something about intellectual property, who understand the online world, the digital world, and understand business issues, and and not just keep those people at very, very expensive lawsuits, which is currently what they do, but also allow that kind of a knowledge to be provided to people in small claims court. So it will allow people to effectively manage a lot of disputes that they have directly with very, very knowledgeable judges, not generalized judges who otherwise, you know, get punished by being given duties in small claims. Thragash, thank you for your opinion. Just wanted to ask again about the failure to identify part of the GOG complaint. I'm not sure what we're talking about here, so I'd have to see that particular indemnification. I'm not sure, to be honest. Colin Winter, YouTube deletes my video. But yeah, there's plenty of other context, so it's hard to gauge in under a few hundred characters. Yeah, I don't really understand what we're talking about here. So feel free, you know, you want me to take you want to send something longer, go on Twitter, send me a DM. I'll take a look, okay? Demon Wolf, just YouTuber Law, how you doing? Colin Winter, right, I agree. And the consequences, like the movie I made about it, might intrigue you. Remix a lot of media to comment around copyright case that allegedly colluded around deleting my video. Cool. And Super Iron Bob, thank you for your thoughtful answer on the access to the law for lay people. Thank you. Damon Wolf, out of curiosity, do you personally think that our country has too many laws? No, I think that our country has an ineffectual Congress at the obviously at the federal level. As a result, we're dealing with old laws that don't make sense, and we don't have any constructive conversations. I think that we have a lot of things to talk about. Things that, no, does this law that was made 20, 30 years ago make sense in today's world and how we communicate in the forms that we are available to us? We can't even have those conversations. Forget about whether or not they can actually pass any laws. So I don't think there's too many laws. I just think we have very old laws and then we rely too much on the court system to try to reinterpret those laws in light of modern days, when in fact it should be up to Congress to revise them, revisit them, hold constructive discussions, and work together. Yes, it's a four-letter word, you know, compromise became a four-letter word, you know, work together towards something that is more useful than today. Even though it doesn't get us everything, I'd like to see better, more relevant laws. Anyway. McFly0097, love it. Have you considered doing an episode on the 96 Telecom Act? No, because generally when I've done videos specific about laws or about a topic, those have not gone very well from a viewer perspective. The ones that do better is when it's tied to a specific case that you guys have an interest in. So, you know, any sort of purely educational videos, there is a core number of viewers that enjoy that, but the vast majority don't. And given the fact that I have only a certain number of videos to do in a span of a week, I kind of focus it on things that are tied to a specific case that might be of interest, so that the educational part comes together with something that actually is interesting to talk about. Cons Clan said, in 2016, my grandmother voted in Connecticut, Delaware, and Florida, and she died in 2013, each time she voted for Hillary. I don't know if that's a joke or it's real, but I would only like to say, based on statistics that I've heard, and I have no way of verifying any of that, obviously. You know, sometimes you heard stuff and you repeat, but you have no idea if it's actually true. They say that there's no statistical proof of any sort of fraud, that fraud has happened on such minuscule scale that has never impacted anything. Then again, if you look at Florida and how close decisions are here, fraud can actually sway things very easily. Old Bill over Hill. At one time, Colorado had a sunset law that required the legislature to review and remove outdated law. They overturned it. What a great law. How about a sunset law for congressmen too? If we find that they're not productive, they're not doing their job, there's also provided a sunset and pushed out of Congress. That would go a long way toward fixing some of the problems. Okay, I think we're at the end here. Thank you so much, guys. I really, really appreciate it. You make this day very, very interesting as always. If you have any more questions, any concerns, anything you want to discuss, just leave them down below. I'd love to talk to you. I'll see you next time.